mix both languages, French and English, in our dialogue. So before we go over to Caleb, let me call upon our chairman, Mr. Mark Mpasa, to address us. Then we will introduce Caleb. Thank you, Mr. Chairman.
Merci beaucoup, Mbouta Edouard, notre secrétaire général. Thank you very much, our General Secretary, Mr. Edouard Jeka. So we'll just cruise very quickly. You know, we are there as CoopCongo. We want to be that bank for the people of Congo in Southern Africa and the world. So today we will have a very short introduction. Then Mr. Keeper will take us through the subject of the day and we'll have questions. As an introduction, we are still, as part of the development phases of CoopCongo, we are still in the norming. We're waiting for one big piece of reply from the Reserve Bank for us to start performing the way we want as the future bank of the Congolese people in Southern Africa and the world. So we were supposed to fulfill the operations, the requirements from the central bank. Donc, comme la future banque des Congolais en Afrique du Sud, nous sommes encore en train d'attendre que les conditions, l'acceptance à la Banque centrale soit finie. Et donc, on attend encore, il fallait les deux conditions. We needed these two conditions to be fulfilled and they are already fulfilled. Donc, les deux conditions qui devaient être remplies sont déjà remplies. Nous attendons maintenant l'interaction avec la Banque centrale. Nous avons demandé la semaine passée, ils nous ont dit qu'ils vont répondre, mais ils n'ont pas répondu. Nous attendons encore. Donc, nous avons issu 2 millions de parts. Jusque-là, la communauté a réservé plus d'1 million, donc il y a moins que ça qui reste. Et nous sommes sûrs que d'ici quelques mois, on n'en aura pas. So we issued 2 million shares, which are already reserved by our members significantly. So more than half of the shares are already reserved. So we are sure that by the end of this year, we will have no shares, especially once we have the approval from the central bank. Les produits que nous aurons, nous avons les produits d'épargne, les saving check account, les produits de crédit, les crédits à long terme et à court terme, et les produits communautaires. Nous aurons l'assistance médicale et l'assistance funéraire. So we have 3 lines of products, saving accounts, credit accounts, and community products. We already started with the funeral assistance, so we will have a lot of calls going forward from our admin, our administrator, Sarah Kabengele will start calling members of the community so that they can register for and acquire the funeral assistance, which is a product we discussed already, and it is approved by the CoopCongo membership. The funeral assistance is not a CoopCongo only reserved product. It is open to the Congolese community worldwide. So anybody who fulfill the conditions to be part of the funeral assistance can join. Donc, parmi les 3 groupes de produits, nous avons déjà les produits, l'assistance funéraire. Ce n'est pas une assurance funéraire, mais c'est une assistance funéraire. De la même façon que nous cotisons dans la communauté quand il y a décès, nous avons maintenant essayé de formaliser ça pour que ça soit un peu plus prédictif. Et d'ici quelques jours, notre administratrice, Sarah Kabengele, va commencer à appeler les membres et les non-membres de CoopCongo pour adhérer à ces produits-là que nous avons discuté depuis l'année passée, bien de mois pour la communauté. Donc, c'est un produit qui n'est pas réservé aux membres seulement de CoopCongo, mais à toute la communauté congolaise de partout à travers le monde. Voilà, donc le produit, on attend la licence pour que nous puissions commencer les transactions bancaires, essentiellement donner des crédits. So we're waiting for our interaction with the central bank so that we can start giving loans. So that one will still wait. Les statements des membres, we're sending regular statements every month. Donc, chaque mois, vous devez recevoir au moins une fois le relevé de votre compte. Si vous n'avez pas reçu, veuillez, si vous ne recevez pas vos relevés de compte, veuillez parler à Sarah Kapengele pour qu'elle puisse rectifier pour vous. So, if you really don't get your statement, please talk to our office. Notre administratrice, c'est Sarah. Elle est joignable au 012 320 2079. Ça, c'est le numéro de notre bureau. So, if you need to talk to her, to Sarah Kapengele, you can reach out at 012 320 279. That is during office hours, c'est pendant les heures de service. L'éducation continue. This is part of the continuous education. Donc, c'est ça que nous faisons maintenant. Donc, nous vraiment encourageons les membres de la communauté à nous joindre chaque 2 semaines pour que nous puissions nous éduquer dans les matières de finances et ça nous aide dans la communauté. Nous préparons encore l'Assemblée générale. So, we will prepare the General Assembly. We'll give you the date as soon as it is decided by the board. Voilà, donc aujourd'hui, nous avons notre présentation avec notre frère Caleb Kipa. CoopCongo vraiment vous remercie pour votre générosité. Caleb est toujours présent parmi nous pour partager avec nous son expérience et son expertise. So Caleb is always with us, sharing his knowledge and his expert advices to the community. Back to you, Mr. Njeka. C'est tout ce que je voulais partager très, très vite. Merci beaucoup.
Merci beaucoup, Mr. Chairman, Marc Mpassa. Sans plus tarder, je vais passer la parole à notre host, qui est our lawyer, Caleb Kipa. Is going to speak to us about surrogacy laws in South Africa. So, Caleb, it's over to you. Thank you.
Thank you, Papa Eddie Njeka, and thank you, Mark Mpassa, for the introduction. As has been stated before, I'm Caleb Kipa. I am an attorney of the High Court of South Africa, and I've been practicing for about 5 years now. Most of my presentation will be in English, and I hope that everyone here will be able to understand everything that I'll be sharing. Please let me know if you can't hear anything or if my internet connection is slow and I'm breaking so that I can just mention whatever I had missed. Please feel free to ask questions during the presentation. You can use the hand up button or just, go off mute and raise your question. So as the title says, I will be discussing surrogacy laws in South Africa, and we thought that this was an interesting topic to discuss because, especially in our community, this is something that really isn't talked about much. And we have a very large Congolese community in South Africa, and the journey of life that we're taught is that, you go to school, then you go to varsity, then you meet your soulmate, whether at varsity or at work, you get married, and then you have a baby, and then you have babies. And that's basically the life cycle that, we're all told as we're young, as kids, both young and men, that that's the process that we do things with. However, that's not always the case. Many people are not fortunate enough, for example, to get to varsity. Other people are unfortunate enough to get permanent employment. And then when it comes to children, not everyone's able to conceive a baby. They might have done all the things correctly, but when it comes to marriage and having children, they're just not able to conceive. Some couples can conceive within minutes of opening like a bottle of red wine and, some romantic music in the background and a few candles, and 2 minutes later, boom, the one, they're able to conceive. Whereas other couples, they've been together for years, 5, 6 years, and after so many times of trying, still not being able to conceive. And in today's world where everything is happening later, people are having children later, the focus is more on young people growing and developing their careers and prioritizing their self growth and development. Couples are starting families at a much later stage. And so what then happens is that the fertility rates and the ability to fall pregnant or to conceive reduces the older you get. And so we're seeing a lot of couples who are getting married later in life, struggling with surrogacy. So in South Africa, surrogacy law is governed by the Children's Act, Chapter 19 of the Children's Act. And what it provides for is mechanisms in place that allow couples who are not able to conceive to have children. The most important thing that I need to mention about surrogacy laws in South Africa is that they are non-profit, meaning that you cannot pay someone to be a surrogate mother, or someone cannot make a profit from this arrangement, but we'll go into more detail. In this session, I will be discussing a couple of things, including the agreement that needs to be drafted between the parties, the requirements for that agreement, the requirements for the genes, whether this agreement can be terminated, and if so, what are the consequences of termination, and then payments that are acceptable under the Act, as well as the identity of the parties. So first, I'm going to be discussing the agreement. So the surrogate mother is understood to be the woman who carries the baby on behalf of the future parent or parent, and they refer to the future parent or parent as a commissioning parent, or commissioning party. So the commissioning party is the parent or the parents that are not able to carry the child to birth, and therefore use the assistance of a surrogate mother. And this agreement needs to firstly be drafted and confirmed by the High Court. So once the couple gets together and they've realized that, look, after years of trying or after months of trying, they've received medical examinations and it's all confirmed that, the wife, for example, is not able to either to create eggs, or has enough eggs to hold a baby, or is not able to carry a child to full term, then what happens is that the couple then starts to seek a surrogate. And once the surrogate has been found, they need to draft an agreement. And this is a very regulated arrangement, in the sense that this agreement needs to be confirmed by the court of law. An agreement with a surrogate mother that is not confirmed by the court of law is void, is invalid, and any child that is born from that agreement will be the child of the surrogate mother. So that means the commissioning parents or the commissioning parties will not have any rights towards that child. So this SMA, I'm going to call it SMA, being the surrogate motherhood agreement. This SMA needs to be in writing. It needs to be signed and needs to be entered into in South Africa. At least one of the commissioning parents, either the husband or the wife, needs to be domiciled in South Africa. The court is relaxed in that requirement because sometimes people are working overseas. So on good cause shown, the court can accept that if, for example, one of the commissioning parents are living, for example, in Brazil, whereas the other partner is here in South Africa. Another consideration is that the surrogate mother's husband, or partner will also need to provide their consent. So in terms of consent, you can imagine how sometimes uncomfortable of a conversation it can be when discussing surrogacy, because the requirement is that a woman can only be a surrogate if she's previously been able to have children. So that means in many instances, or in most all instances, the surrogate mother either has a partner or is a single parent. But the bottom line is that the surrogate mother has had a child before and successfully was able to carry a child into this world. And what the Act does is that it recognizes that the surrogate mother or the commissioned parent might have a spouse, and thus requires them to get their consent. So if you're the spouse of either the commissioning parent or the surrogate mother refuses to give their consent, then or unreasonably withholds such consent, the court may still confirm the agreements. And that's why it's very important as a couple, before commencing proceedings, to discuss between each other very well, possibly going to counseling to really understand the ramifications and the consequences of the decisions that will be made and the impact that it will have. And because you want to make sure that all of that is clear before you involve a third party, being the surrogate mother, and then putting together an agreement, and then taking things from there. Also, in terms of very important when it comes to surrogacy is the genetics. Before I move into genetics, I just want to stop there quickly and ask if there's any questions. Okay, no questions. No.
Sorry, Caleb. I don't know if this will be a good place also for Mr. Njeka to give a summary in French, if he's ready for that.
I think that would be good, yeah.
Because you've gone very, very deep into this is...
Okay. Je vais essayer de traduire un peu en français ce que Caleb vient de nous présenter, la première partie ici. La porteuse, je crois, c'est peut-être l'expression en français, est régie par chapitre 19 de Children Act ici en Afrique du Sud, donc l'acte des enfants, je crois, dans la Constitution. Et c'est aussi non, les parties ne sont, les donneurs ne sont pas supposés payer. C'est quelque chose qui doit être fait gratuitement, selon la loi en Afrique du Sud. Et les parties qui donnent, la femme qui donne les œufs et l'homme qui donne le sperme, en anglais, ce sont des commissioning parties. Je ne sais pas si ça se traduit en français, quoi, commissionnaire. Okay. Donc, mais c'est en français, je crois, c'est donneur. Et la mère qui porte la grossesse, c'est la mère porteuse. Et la loi sur la mère porteuse ici en Afrique du Sud est contrôlée par le tribunal. Les parties doivent s'asseoir ensemble, écrire leurs agréments ensemble, et ça doit être ratifié par le tribunal. Si cette procédure n'est pas suivie, donc c'est illégal ce qu'ils sont en train de faire. Donc la finalité doit être faite par le tribunal ici en Afrique du Sud. Et puis, au cas où la femme est peut-être mariée, elle doit d'abord avoir donné naissance avant d'entrer en agrément pour porter les œufs de l'autre partie. Et son partenaire ou ses parents doivent aussi donner leur accord lorsqu'on régit la loi. Alors, je crois pour cette partie, c'est un peu ça. Merci. Caleb, à vous.
Thank you, Baidi. You've captured all of that very well. I'm going to continue. So in terms of genetics, one thing that's very important to remember is that at least the genetics of one of the parents must be used in the artificial fertilization of and conception of this child. So for example, either one of the commissioning parents, if the sperm is being used, if the egg of the mother is being used, then obviously the egg of the wife, let's say the commissioning parent being the wife, her egg is being used, and then the sperm of the father, the commissioning father, then that is fine. Or if the woman is not able, the commissioning wife is not able to produce eggs, and what happens is that they're actually going to be using the eggs of the surrogate mother, then at the very least, then the sperm of the commissioning father must be included. So at least one gamete, either the egg from the commissioning mother or the sperm from the commissioning father, must be used when fertilizing the egg. It cannot be a situation whereby the surrogate mother uses her own egg and then the sperm of a different person that is not either the commissioning father or mother. The court will not accept that and will not recognize an agreement, and any child born from that will be the children of that mother and the donor father who provided his sperm. So I think that's very important to discuss. I think where there's gaps in the law in this regard is where, and which makes sense. Because if you think about it, if both couples are not able to conceive and have children, the father is infertile, the wife is infertile, the husband is infertile, the wife is infertile. For example, the husband is infertile because he has a low sperm count, the wife is infertile because she's not able to produce eggs. That means the couple is not able, both are not able to have children. So there isn't, the law doesn't give you any right to get a surrogate mother to ask her to conceive a child with another man for you to then take over and adopt when the child is born. There is no law that provides for that in South Africa. And so for parents who find themselves, or for couples who find themselves in that situation, the other available option would be then the adoption route. But the point we're trying to make here is that for there to be a valid SMA being the surrogate motherhood agreement, at least the genetics of one of the commissioning parents or parties must be used in the process. So in terms of what the court requires, there's a couple of things that the court want to see in this agreement before they can confirm. They want to understand that the surrogate mother has the capacity to enter into this agreement. So that means it's someone who's mentally stable, someone who is healthy and strong, and the court will be satisfied by providing them with evidence of medical records, psychometric assessment, and so on. The commissioning parents must record in writing that they are competent to act and enter into this agreement. and that they are suitable parents, suitable persons to accept parenthood. So you need to write to, in your application, you'll set out the fact that you have a good career going on, stable income, you're married, you stay in a good environment, and the intention is to create a savings account or trust accounts for the child, and the child will be going to, these are the proposed schools when the child's born. So just putting together a story to the court of what they are to expect, attaching bank statements and proof of assets and all of that stuff that can convince the court, which is kind of unfair and sad, because there are people having children who have nothing, literally nothing, and they can have children. But in this regard here, you need to convince the courts that you need permission from the courts to be a parent. You need to convince them that you're good and you're qualified, whereas other people, they don't need to convince anyone. It's just by the grace of God that they, through their activity, they're able to fall pregnant. The agreement is also required to provide how like I said, how the child will be growing up, and also about the personal circumstances of the family and those involved. So they also want to know about the medical history. They want to understand also about the surrogate mother. Does she have children? Does she have a partner? What is the situation there? Because what the court wants to achieve is if this agreement is given the go-ahead, they want the interest of the child that will be born to take paramount importance, and to ensure that all the parties' rights are respected, and to ensure that all the parties are on board, because when that happens, it avoids a lot of drama and going back and forth, which would definitely not be in the best interest of the child to be. What a lot of people get confused by is what happens, what's this effect of the surrogate motherhood agreement on the status of the child? When the child is born, whose child is it? Is it the child of the surrogate mother who carried it? Is it the child of the commissioning parents? What is the status? So a valid surrogate agreement, motherhood agreement, the effect of that is that any child born of a surrogate mother is, for all intents and purposes, the child of the commissioning parents from the moment the child is born. So from the moment, as soon as the baby is out of the womb, the parents are the commissioning parties. The surrogate mother is obliged to hand over the child to the commissioning parent as soon as reasonably possible after birth. And you will find that in many instances which is a very difficult, and giving birth is a very difficult and emotional experience. And a lot of women form bonds with their children the moment as they're giving birth. And when they see their babies and hold their babies for the first time, it's so hard, that connection, it's so hard to let go. And so you'll find that in many instances, as soon as the mother is given birth, or the surrogate mother is given birth, she's then not allowed to hold the baby, or is prevented from holding the baby. And the baby is taken to those rooms where they take the newborns to have them checked out and put them in this little cubes and stuff. And that's just so to help alleviate the emotional bond between the surrogate mother and the child. And so again, it's a very emotional journey throughout. Another effect of the surrogate motherhood agreement is that the surrogate mother and her husband or partner do not have any rights of parenthood on the child. And when the child grows up, the child will not have any claim for maintenance against the surrogate mother or husband. The child will only be able to claim maintenance from the commissioning parents. Now, another question people would like to ask is about termination. But before I get to termination, I think I should just stop there and then have Papa Eddie just translate in summary.
Thank you, Caleb. Bon, je vais juste résumer un peu. C'est que on vient de parler à la deuxième partie ici sur le génétique. C'est par la loi, soit les deux parents, l'homme va donner le sperme et la femme les œufs pour la mère porteuse. Mais au cas où l'un des donneurs n'est pas à mesure de donner soit les œufs, soit le sperme, par la loi, on peut trouver soit la mère porteuse peut donner les œufs et le père donne le sperme, ou bien la famille peut chercher le sperme à l'extérieur, mais les œufs doivent venir de la femme qui donne pour que la mère porteuse puisse faire. Si les deux parents ne sont pas à mesure de donner, ils ne sont pas à mesure de soit produire le sperme, c'est très bas, et les œufs aussi. Par la loi en Afrique du Sud, ils ne sont pas autorisés à trouver la mère porteuse qui doit donner naissance à l'enfant et eux, à la naissance, soit adopter cet enfant. Non. C'est la façon dont ils peuvent remédier à leur situation, c'est passer à l'adoption tout simplement d'un enfant pour leur famille. Et puis, c'est que le tribunal va chercher à voir dans l'agrément entre les deux parties, c'est la santé des deux parties, la mère porteuse ainsi que les parents qui qui veulent avoir l'enfant par la mère porteuse, le travail des donneurs. Est-ce que à la naissance, l'enfant aura va grandir dans un bon environnement, l'école où ils comptent envoyer leur enfant après la naissance. Ils doivent détailler comment l'enfant va grandir, la santé de la mère porteuse aussi. Et puis, autre chose, par la loi en Afrique du Sud, l'enfant, la question qui a été posée, qui est la mère de l'enfant? La mère de l'enfant, c'est la mère qui donne, ce n'est pas la mère porteuse. Et pour éviter, parce que la grossesse, tout ce cheminement des événements, il y a aussi l'attachement émotionnel qui va avec. Et par la loi, ils ne veulent même pas que la mère porteuse puisse toucher à l'enfant, puisse porter à l'enfant à la naissance. Tout ça, c'est pour éviter ces attachements émotionnels. Dès que la mère porteuse donne naissance à l'enfant, elle est supposée donner l'enfant automatiquement aux parties qui ont donné pour que eux, ils puissent continuer le voyage avec l'enfant. Donc, la mère porteuse, même à la longue, il faut que l'enfant demande, ici en Afrique du Sud, les enfants demandent aux parents les frais de tenue et tout, l'enfant n'est pas autorisé à aller demander les frais à la mère porteuse. La mère porteuse n'a rien à voir avec l'enfant. Ce sont les parents qui ont donné leur sperme et les œufs qui sont supposés prendre charge de l'enfant. Merci. À vous, Caleb. S'il y a des questions jusque-là, vous pouvez soit lever la main, soit poser, s'il vous plaît.
Thank you, Wavy. Now I'll be discussing termination of the surrogate mother agreement and the consequence of termination of the pregnancy. So if we are in a world where the surrogate mother agreement is terminated by the parties, the surrogate mother, first of all, if the surrogate mother is also a genetic parent, so meaning she's carrying this child, but she's also using her own egg, and instead using the sperm of the husband, of the commissioning father, she's entitled to terminate this agreement that was confirmed by order of the High Court. She's entitled to terminate it within 60 days of giving birth to the child. I'm not too sure under what circumstances why one would want to do that, but I can imagine it would be in instances where, for example, the surrogate mother wants to divorce or is not in a partnership with the donating father, and I can see that in that situation it would make sense that a surrogate mother would want to terminate. And the reason why they should want to do that is probably because she would want to keep and maintain sole parent custody of the child, and to keep the child and be the primary caregiver. But the instances of that happening are very far and wide. But yes, just for your information, that the surrogate mother, who also is a genetic parent, so she's using her own egg, is entitled to terminate the surrogate mother agreement within 60 days after the child is born. If she does that, she does not incur any liability to the commissioning parents. So the commissioning parents cannot sue her for anything, but she will be expected to pay back any compensation she received from the commissioning parents. I just need to make a point here that you recall at the beginning, I mentioned that a surrogate mother may not charge commissioning parents for carrying the child, nor can they make a profit, but they can claim reasonable expenses such as medical bills, being put on a certain diet, loss of income. So you can imagine that some surrogate mothers are working and they'll have to take leave, or they run a business and they won't be able to make an income because they're pregnant and carrying the commissioning parent's child. And in that case, they can claim the loss of income as well. The effect of terminating the surrogate motherhood agreement is that any parental rights that were established are terminated and then belong and vest with the surrogate mother, her husband or partner. So the commissioning parents will have no rights over the child. And furthermore, the surrogate mother and husband, the surrogate mother and husband the surrogate mother and her husband or partner, if any or if none, the commissioning father is obliged to accept the obligation of parenthood, and the commissioning parents will then have no rights of parenthood over the child after this agreement is terminated, and they can only obtain such rights through adoption. And as a couple going through this, you don't want to find yourself in a situation like that, whereby you need to now go through adoption to acquire parental rights, because that's another long and daunting process on top of just the surrogacy journey. So it's very important as a couple right at the beginning to have an open discussion about what the goals are, what are the intentions, and also go into a process where you find reputable surrogate mothers. I know that there are websites and agencies that have profiles on women who have done this before. And it's almost like an interview where, you interview, especially if the egg of the surrogate mother will be used. The couple will want to know, what's her background, where she comes from, what are her beliefs, what are the family health status, are there any hereditary illnesses, because they obviously want the strongest and healthiest baby possible. And also race plays a factor as well. They probably want a white child or black child or mixed race child or Indian child. So they'll look for a surrogate mother that, would meet that criteria for them. There are instances where the surrogate mother can terminate the pregnancy. As you know, abortion in South Africa is legal in terms of the Choice on Termination of Pregnancy Act. And the Act sets out timelines within which abortion can take place, within which a pregnancy can be terminated. And if the surrogate mother terminates the pregnancy during those periods provided in the Act, then she has every right to do so. But she's informed and advised that she should first consult with the commissioning parents of her decision prior to terminating, and not to just inform them, but to also consult with them and, explain to them why this is happening. And, because again, this is a very emotional journey. It's, there's a lot of hearts involved, a lot of money, a lot of attention, a lot of discussions. And sometimes you'll find that it's difficult on the one side for one person to terminate. But if she wants to, and she's met all the requirements in terms of the Act, and she's consulted with the couple, she's let them know she has every right to do so. And as such, you want to make sure that if you're going to use a surrogate mother, you need to use someone who has experience, is stable, understands the consequences, understands their role, is level-headed. And that's why the whole process involves medical examinations, psychometric examinations, just psychiatric examinations, just to ensure that the surrogate mother is in the right space and is able to take upon this responsibility of carrying this child to full term and then handing over the child to the commissioning parents. I've mentioned regarding payments that no person may, in connection with a surrogate motherhood agreement, give or promise to give any person any reward in cash or in kind. You're only able to compensate the surrogate mother for compensation for expenses that relate to the artificial fertilization and pregnancy of the surrogate mother, the hospital bills, the loss of earnings, any insurance to cover the surrogate mother for anything that may lead to death or disability. So this world is very sophisticated because there is actually even insurance to cover the surrogate mother in case she passes away or is disabled. So if she passes away, then the beneficiary would most likely be, if she had a partner, the partner, if she had children, the children, or whoever else she has in her will. If she's disabled, then she would be the beneficiary. And then, because there are those instances whereby people give birth, whether natural or by cesarean, where they are disabled because something went wrong during the pregnancy, during the delivery of the baby, and now they've been left disabled, and that insurance then pays them out for that.
Sorry, Caleb, before you continue, there is a question, maybe you can answer, then proceed. Thank you.
Okay, cool.
Yeah.
Okay, received a question from Jay. Will the surrogate mother have to pay back the money, and can she be forced to pay extra for emotional impact on the commissioning parents? So the Act is very clear on this regard. The only liability that the surrogate mother will have is to pay back any amounts paid for purposes of pregnancy, being hospital bills, accommodation, loss of income, all of that. But what they won't be able to pay back is emotional impact on the parents. So that will be damages for almost like, one would say like pain and suffering, which is a term that is used, for example, if you're in a car accident, and you're recovering, you can sue for actual damages and pain and suffering. But in this regard, unfortunately, a commissioning parent will not be able to sue for emotional, damage or pain and suffering or some sort of emotional impact, which it will have. That's the reality. But unfortunately, the way things are set up and the Act is drafted, the only liability that a surrogate mother would have is for payment of those main items: medical bills, loss of income, accommodation, diet, and whatnot. Cool. I hope that answers your question. I will be continuing. When it comes,
yes, proceed.
Can proceed. Okay. When it comes to privacy, the Act is very emphasizes on this, and they've included this clause because it's important to protect the identities of the parties involved. And so the Act has provided that the identity of the parties to court proceedings with regards to a surrogate motherhood agreement may not be published without the written consent of the parties concerned. No person may publish any facts that reveal the identity of a person born as a result of a surrogate motherhood. So essentially, the identities of the parties involved, all of them, are to be kept confidential. This is important because how families do their family planning and how they build and what they do is not something that should be for public record. It's all about protecting the dignity and the privacy of the individuals in place. And so, yeah, their identities cannot be, so you can't, for example, be writing articles or posting about it on Instagram or on social media or sharing it with news with other people, because that will be an infringement of their privacy. Recently, there was a court judgment in the Pretoria High Court where they've set some new guidelines to take into consideration before granting surrogacy agreements, before confirming surrogacy agreements. Because you remember that the commissioned parents and the surrogate mother, they come together, they draft this agreement. This agreement is then taken to court. And obviously, by the time it's taken to court, the parties would have made sure that they've satisfied all the requirements, and they've also attached proof of the requirements being satisfied. What the court has now done recently this year is they've added they've set guidelines. So it's not a requirement, it's not compulsory, but they've understood that there's a gap in this process and that needs to be addressed. And the gap in this particular instance is the fact that it is a definite that the surrogate mother does have children, would have at least one child, because that's the requirement. And what the courts have come to understand is that the surrogacy process, they want to understand what is the impact of the surrogate mother being pregnant on her actual child in the house. So if you can imagine, you are the child of a woman who is carrying a baby for another couple, and you're living with your mom, or you're seeing your mom and she's coming home every day, and you're understanding that she is carrying and you're expecting her, to give birth and whatnot. And then 9 months or 8 months later down the line, your mother comes back home. She no longer has a big tummy because she's given birth, but on top of that, she doesn't come home with the child. And it sometimes can have the psychological effect on a child, who sees this. And so the courts want to understand, how does a surrogate pregnancy affect the surrogate mother's own children, And so what they've done is that they've put in this guideline where that they require that medical clinical assessment of the surrogate mother should be made, but there should also be a clinical interview with the surrogate mother's children to prepare them for the surrogacy journey. So it's not just enough or sufficient for the surrogate mother to talk to a kid and say, hi guys, I'm going to be pregnant. You're going to see me, I'm going to have a child. I'm going to be carrying a baby inside of me, but it's not mine. And the reason why you would prefer the conversation being done with a clinical, for it to be done by a clinical interview is because children are very sensitive and very delicate, and you want the right social worker involved, or the right clinician who is doing the psychological assessment to be in that interview process, to be able to speak, to relay the information to the child in a manner that the child will understand. Because sometimes, children, they see things black and white. Two parents get together, they love each other, they have children, and there's all these other complexities in the real world, and we don't want to burden them with all that information. So through this clinical interview, you have experienced practitioners who are able to manage and conduct this process, where the surrogate mother can have this conversation with the children to prepare them. And, and I think the biggest lesson that a surrogate mother can teach their child throughout this process is the ability and the power of being a blessing to others, and the ability of being help to others and going beyond the ordinary. And those are values that you would instill in your child, that, in this world, we are here together, we're here to help each other, where one is down, they get firsthand experience to see that, and it's a beautiful thing. But it's definitely something that needs to be talked about and managed in a safe way, because it can have an impact or an effect on the child's emotional being, seeing this process going through. And that brings me to the end of my presentation. And just in summary, the legal effect of this agreement is that the child that is born out of surrogacy is, for all purposes, the child of the commissioning parent, unless the agreement is terminated or the pregnancy is terminated. No compensation may be paid, save for reasonable expenses like medical bills, transportation, food, diet, doctor's appointments, loss of income, and the sort. The child that is born out of a surrogacy agreement is the child of the surrogate parent, and therefore the child there's no claim of maintenance against the surrogate mother unless the surrogate motherhood agreement is terminated.
Thank you very much, Caleb. There is one question on the chat, and I would like to ask everyone else to either post your questions in the chat, or you can also ask questions directly.
Okay.
That's
Right.
it.
Thank you. All right, I'm going to answer the question from Mr. Mark. So if the surrogate mother was to run away a few weeks before giving birth, should be doing it in bad faith. It is not criminal for her to run away, nor is it an offense. Although there might be room to argue that the termination agreement was not validly terminated. The surrogate motherhood agreement was not validly terminated because at the end of the day, it's an agreement, it's a contract, there are obligations, and there's ways to terminate the agreement. You'll find that the clause for termination in the agreement is, for example, that the parties must agree in writing that they must terminate, or the parties must discuss, or whatever. So if in that particular agreement, there are particular provisions for how to terminate the agreement, and the mother doesn't adhere to that, and all she does is just disappear, the couple can still approach the court and say, look, we have a valid agreement. This was not terminated. The lady disappeared, so she's run away. and we don't know if she's given birth. But when she does give birth and if by the time she's given birth and we're not there to take the child, then it would amount to kidnapping. That's when it becomes criminal. So that's why it's very important to seek a lawyer when drafting the surrogate motherhood agreement, because you want to really cover for worst case scenario. It's always hunky-dory and it's always roses and peaches when discussing at the beginning. Yes, I will be there, I will support, I'm happy to carry this child, it's amazing, I'll be there, I'll give you the child by the time, I give birth and whatnot. But the contract needs to take into consideration worst case scenario. How do we validly terminate this agreement? Just so that it makes it difficult for a situation whereby the mother runs away, and in the event that she does without terminating the agreement lawfully, then it would amount to kidnapping. The parents would still have the right.
Thank you very much, Caleb. D'autres questions? Plus de compréhension? S'il vous plaît. Nous sommes presque au bout de notre temps. S'il y a encore des questions. La surrogacy, c'est une science que nous devons aussi introduire dans nos vies en tant que Congolais, parce que nous vivons dans la société mondiale, nous appartenons au monde, et c'est quelque chose qui va être avec nous de plus en plus. Thank you very much.
No,
Jay.
I agree.
Okay, yes, go ahead.
Yeah, I know. I was just saying, Papa Eddie, that I agree with you, because I think a lot of what I've seen, especially growing up, is that a lot of couples in our community, they really go through this whole emotional, almost abusive marriage cycle, whereby they're getting taunted and ridiculed by family members or close relatives or whatever for not being able to give birth or bear children, even though it's a very private matter. And science is not giving us options. The law has given us options. There's not just one way to do things anymore. And so it requires us to be open-minded, to be educated, to be informed, because again, surrogacy is not something that requires millions or even hundreds and thousands of rands, because remember, you're not paying the wife like a profit. You're just paying reasonable expenses, which you would have incurred if your wife is pregnant. Doctor's expenses. The one thing that's different would be the loss of income. And that might be a tricky part. But I think, if you're really in that world, it would make sense and it would be worth the expense, because at the end of it, you will have a healthy, bouncing baby, boy or girl or twins, whichever the case is. But the point is, as Congolese people, we should open our eyes, we should open our minds. Infertility can go both ways, both men and women, and there are solutions. So you'll find that some women, they can carry a child to full term. They just don't have, they don't have the eggs, or they're not able to have the eggs fertilized in them. And then there's things like artificial fertilization, which they call IVF. A lot of white couples do it. A lot of couples in modern countries do it. So that's something that our people need to start to learn about, so that, it takes away a lot of the emotional drama that comes with not able to conceive, that we see a lot in our communities, and divorce rates that happen when couples aren't able to conceive as well.
Thank you very much. Comme Caleb vient de dire, donc dans notre communauté, c'est ce que nous vivons pratiquement presque tous les jours. Il y a des familles, l'homme et la femme se marient, ils ne peuvent pas avoir des enfants. Et pourtant, aujourd'hui, il y a la loi et la science qui sont là pour aider ce genre de famille. Il y a eu des divorces parce que la femme ne conçoit pas, mais le problème peut aussi être chez l'homme, pas seulement la femme. Donc, on peut aussi embrasser la science et la loi aujourd'hui qui est là pour remédier à ce genre de situation. Il y a la surrogacy, il y a l'insémination, tout ça, c'est la science qui est là et qui a fait à ce que nos problèmes émotionnels de ne pas avoir les enfants dans la famille, ou soit le mari qui avait prié à Dieu que non, je veux avoir tous mes enfants avec ma femme et la femme ne conçoit pas, il est maintenant obligé de peut-être aller à l'extérieur, chercher une deuxième femme, chercher les enfants. La solution est là, la science et le droit nous donnent des possibilités de rester avec ta femme et les enfants que vous pouvez avoir d'une autre mère porteuse, mais c'est votre enfant par la loi. Et là, ça va alléger vos émotions. Notre temps est arrivé à la fin. Merci beaucoup pour la participation. Je voudrais remercier d'abord Caleb, mais je passe la parole à mon chairman, M. Marc Mpassa, pour le mot de la fin et les remerciements. Merci.
Merci beaucoup, M. Njeka. Nous sommes vraiment très enchantés. Nous savons comment remercier notre frère, M. Caleb Kipa, pour d'abord un élan très volontaire de vouloir aider la communauté et de partager cette expertise. Ça, c'est des sujets très importants, modernes. Vraiment, merci pour avoir d'abord suggéré le thème et ensuite pour l'avoir partagé de la manière dont vous avez fait là. So we thank Mr. Kipa for first choosing the subject because these were his own suggestions to us, to the community, and also for availing himself to share the knowledge and the time with the community. We thank you so much, sir. So, merci beaucoup à tout le monde qui a participé et merci à ceux qui vont visionner. Nous sommes là pour partager ensemble afin que notre communauté puisse avancer. So, we thank everyone that participated and we hope together to grow as a community for the benefit of all. Thank you very much, Mr. Njeka. Back to you.
Thank you very much. We are meeting again in 2 weeks' time. Caleb is going to develop.
Thank you so much.
Yeah, so we are meeting with Caleb in 2 weeks' time again. So please be there. The subject that Caleb is bringing to us, these are the heart of our marriages. And thank you again, Caleb. And yes.
Awesome. Yes, I will be talking to you guys in 2 weeks. We'll be discussing the different matrimonial property regimes in South Africa, and yeah, there'll be exciting times as well. So thank you, everyone. Really appreciated it, for your attendance and participation. Thank you, CoopCongo, for having me. And yes, we'll see each other in 2 weeks' time.
Okay, thank you, and bonne fin de semaine. Bonne fin de semaine, hein, c'est ça.
Okay.
See you in 2 weeks' time. Merci.